Viewers, greetings and namaskar. I welcome you to this podcast from guide to IBC.com. On 6th of April, Insolvency Bankruptcy Code Amendment Act 2026 came into force, came into being rather to say. And the law has introduces many new directions. Like for the first time, we will see creditor-initiated insolvency resolution process, group insolvency, which was there. I wouldn't say that it was not there. In Section 7, you can have group insolvency. But this is coming in as a separate branch. That what makes it different. But the law hasn't come into effect as of now. And of course, I forgot to mention, fast-track insolvency is going to go out. The law hasn't come into effect as of now because it will come with regulations and things, and along with it, because the law has to operate. So once the law comes into force, you will find it on the website. Now, this particular podcast focuses on judgments of various courts like Supreme Court, NCLAT, High Courts, etc. during the period from 1st April to 15th of April. So with this, I take you over to the presentation.
You can see section 14 of Moratorium on your screen. Let us come. Section 14.1 says what? Subject to provisions of section 2 and subsection 3, on the insolvency commencement date, the adjudicating authority shall, by order, declare moratorium for prohibiting all of the following, namely. That means subject to provisions of subsection 2 and 3 on the insolvency commencement date, the adjudicating authority shall by order declare moratorium for prohibiting all of the following, namely, in D, what did it say? Recovery of any property by an owner or lessor where such property is occupied by or in the possession of the corporate debtor. Clear? Now let us go and see what is Regulation 31 saying. 31D to be precise. Regulation 31 deals with insolvency resolution process cost. B says, amount due to a person whose rights are prejudicially affected on account of moratorium imposed under Section 14, subsection 1, subsection D. So this means that 14.1D, if someone's right is being hampered or is prejudiced, in such case, cost paid thereof is liquidation, is CIRP cost. Now, our point of interest is topic number 17, which is a new topic. The possession of a tenant who had ceased to be a tenant after expiry or termination of the lease is protected by law until he is ejected. So even if the tenancy has expired, lease has been terminated, even beyond that, his right is to be protected until he is duly ejected. The case is of, let us come to the case. Sudha Apparels Limited versus Ravi Sethia RP, Company Appeal so-and-so of 2024, very recent judgment of NCLAT. This is the case. It's quite a lengthy case in which what happened, the company had been on a lease of a property in which their main store was located. But the owner of the property moved it to cancel the lease, went to arbitration, and an arbitration court, an order came out that the corporate debtor should not create any third-party rights. In the meanwhile, he went for ejection of the party, but in between the CIRP was there, and so on and so forth. So if the matter went to NCLAT, NCLAT did retain the right of the person, but NCLAT, then the matter went to the jurisdiction of NCLAT. It's a very interesting read. So I would rather suggest that you should go through the judgment, excerpts of the judgment featuring on the website. Let me take you over to the slide which I prepared for you. In this particular case, NCLAT based its judgment based on Supreme Court, Honorable Supreme Court's judgment in Rajendra K. Bhutta versus Maharashtra Housing and Area Development Authority and another, R.V. Bhupal Prasad versus State of Andhra Pradesh and others, and Lalu Yashwant versus Rao Jagdish Singh AIR. I've already read the main point, the topic, so I'm not repeating it. So, what NCLAT said was that 14(1)D of the code is absolute and covers property which is in possession of the corporate debtor. This is further evidence from the reading of section 31B of CIRP regulations, which I read for you, which states that amount due to a person whose rights are affected under 14(1)D of the code shall be treated as CIRP costs. It shows that even termination notice delivered before the initiation of CIRP, section 14(1)D will be applicable and restrict the lessor from recovering the property occupied by the corporate debtor. So even if eviction notice was given prior to institution of CIRP, in such case also the right of the tenant will be covered. If it is under moratorium, CIRP is there and it is under moratorium. 14(1)D of the code is applicable when corporate debtor is in actual physical occupation of the property under subsisting joint development license and the termination sought to recover such occupied property during moratorium. The possession of the tenant who had ceased to be a tenant after expiry of termination of lease is protected by law until he is duly ejected, which is held in Lalu Yashwant Rao Jagdish Singh case. Actually, R.B. Bhupal Prasad versus State of Andhra Pradesh, wherein the judgment of Lalu Yashwant Rao and Lalu Yashwant versus Rao Jagdish Singh was referred to, and this was the verdict of the Honorable Supreme Court. The appellant terminated lease agreement on 14/4/2003 and subsequently filed application under Section 9 of Arbitration Conciliation Act 1996 to injunct the corporate debtor from alienating the property before commercial court. The learned commercial court passed an order on 29/4/2023 that the corporate debtor is purportedly alienating and encumbering assets and directed the corporate debtor to refrain from dealing with the property or disposing of the property, which I've already told you. The appellant had violated the provisions of Section 14 of the Code by not allowing electricity distribution company to reconnect electricity, in effect affecting the going concern status of the corporate debtor. Now, this comes under Regulation 32, you'll remember. This is essential service. And definitely by not allowing electricity department to reinstate electricity, the appellant had caused violation of Section 14 of the Code. The property is the only premises where operation of the corporate debtor continued until under its brand Central. Furthermore, 80% of the corporate debtor's business comes from this property. 16 stores have been vacated during CIRP, and resolution professional team is currently in the process of vacating 7 more stores. Only 2 stores as on date are operational, that is Central and Surat stores. This is the Central store. This case does not deal with recovery of any property by owner or lessor, where such property is occupied by or in possession of the corporate debtor in terms of Section 14(1)D of the Code. In the present case, the resolution professional is still in possession of the leased property. Thus, we find no force in the appeal and it is dismissed. The resolution professional is still in possession of the property. The CD is still in possession of the property. The resolution professional stroke the learned NCLT to conclude the proceedings as expeditiously as possible, preferably within 3 months from today. That is, this cannot be allowed because CIRP is going on. Let CIRP get over. You cannot stop a business right there and ask them to move out just like that. It is not possible. So time has to be given. So this is an interesting topic, and especially the headline that possession of a tenant who had ceased to be a tenant after expiry of termination of lease is protected by law until he is duly ejected is something which we need to keep in mind while dealing with other matters. So this is very important. With this, we move on to the next slide. We are on the screen of, or rather the dashboard of section 18 of Insolvency Bankruptcy Code in Guide to IBC website. We have various topics. The topic for interest in this particular presentation is topic number 6, which says IRP or RP to ensure that the CD continues operation as a going concern and is duty bound to manage its operations. The case is Satinder Singh Bhasin versus Government of NCT of Delhi, miscellaneous application number so and so, Supreme Court. This is a huge judgment, spanning about 106 pages. And I would recommend, though this does not actually deal with it, it contains Insolvency Bankruptcy Code, and it is essentially a bail petition which the Supreme Court has denied. Had originally granted bail and then denied granting of the bail. This deals with the home buyer case. And it the turns and things, and it has been segregated into various portions, as you will see that IRP and insolvency proceedings, UPSDA dues, alleged violation of conditions, condition to deposit 50 crores, then construction not complete, no settlement, no intent to do so. And then court reaches commission of similar offense. And then court reaches a conclusion. So I would recommend, needless to say, that I would recommend everyone to go through this. Instead of going through 106 pages, which you should, you can go through the excerpts, which will be much shorter. But however, for the sake of this particular presentation, let me take you over to the slide which I prepared for you. You see, a petition was preferred by allotees under Section 7 of IBC on so-and-so date seeking initiation of CIRP against the company and another concern of the petitioner pertaining to Grand Venezia Commercial Towers Private Limited. The Section 7 was invoked on account of failure to complete construction and hand over units. Thereafter, other corporate debtors also joined the proceedings as well. And on 4/12/2023, NCLT admitted the petition. So this pertains to a home buyer project. Now, the construction was not complete, and which constitutes a default. And Section 7 was admitted because thereon. The NCLAT had appointed an observer by order dated so-and-so of 25, who had submitted a report on 15/5/2025 pertaining to indicating the status of construction of units. Supreme Court had also asked UPSDA to conduct a site visit, and pursuant to an order dated 29/4/25 of this court, that is Supreme Court, UPSID officials had visited the project premises and found that the units to be in incomplete condition. A report was filed on 1/5/2025 to that effect. So think of it, the project started and the project remains incomplete. IRP alleged that the petitioner had siphoned of funds to the tune of 74 crores from GVC TPL related concerns after imposition of moratorium. It is a matter of record that the transaction in question was undertaken during the period of moratorium. The order dated 7/12/23 passed by NCLAT required that the status quo to be maintained. Forget about the status quo, forget about moratorium. the promoters of this home buyer, this real estate projects, they care to hoots. They are concerned with making money. And by hook or crook, the money is siphoned off. Despite being enlarged on bail by this court and being asked to settle the claims of the allottees, the petitioner has still not submitted the final undisputed list of allottees to UPSIDA. An alarming aspect is that no court resolution has been passed by BIIPL, that is the company which is in CIRP, before disbursal of the amount to secure bail, which is 50 crores. So forget about compliance of Companies Act. No board resolution was passed for disbursal of the amount, and which was used by the promoter to secure his bail. Despite the passage of time, a large number of allottees have neither received possession nor refund. Even in case where settlement agreement have been executed, the terms thereof have not been fulfilled. So everything is in limbo. Some projects have been, some little bit of a structure has come up, and that's all. The investors are, the home buyers are at the mercy of this guy, and who's on bail. Given that the statutory remedies against the admission of order of IBC proceedings have been exhausted, the complete management of the affairs of BIIPL ought to be handed over to IRP at the earliest. Seeing that there is no other way out, the Supreme Court directs that the entire management of the project should be handed over to IRP. The IRP informed that the claims received are more than 1,400 crores, with approximately 670 creditors. Also, claims of other creditors are more than 460 crores. The promoter of this project said that I have given 50 crores. With that, you settle their deals. Think of the audacity of the guy that there are dues of 1,400 crores and 670 creditors, and 460 is due from other parties. And he says that settle the dues. And the question is, that in between, underlined is a question. Now you hand over the project to the IRP. He's a lone person. Of course, he'll be helped by home buyers, he'll be helped by financial creditors. But can they, even UPSIDA will help, but even then, can this project be revived? That's a big question. Okay, the bail of this guy is cancelled. Bail petition is cancelled. But will that solve the problem? Okay, as far as the court is concerned, within its boundaries, court has tried its effort. It has said that give the possession to IRP, give the management to IRP. But let's see what happens. With this, we move on to the next slide. We are on the dashboard of topics of section 30 of Insolvency Bankruptcy Code, and which deals with submission of resolution plan. We are coming to topic number 53. I was expecting a case like this. There is a small anomaly in the law. I wouldn't call it an anomaly. Being an insolvency professional, there is a factor on which I would rather call it a factor. I was hoping in the last 8 years that someone would take advantage of it. So let us analyze. Let us discuss about what has happened. Section 50, topic number 53 says the fact that resolution value is lower than the liquidation value does not permit deviation from the mandate of section 32B. Now, what is section 32B? Subsection 2 says the resolution professional shall examine each resolution plan received by him to confirm that each of the resolution plan. B says provisions for the payment of debts of operational creditors in such manner as may be specified by the board, which shall not be less than 1, the amount paid by such creditors in the event of liquidation of the corporate debtor under section 53. The amount that would have been paid to such creditors if amount made to be distributed under the resolution plan had been distributed in accordance with the order of priority in subsection 1 of section 53. 53 is waterfall mechanism, as we know. Whichever, now the sentence continues, whichever is higher, and the provision for the payment of debts of financial creditors who do not vote in favor of the resolution plan in such manner as may be specified by the board, which shall not be less than the amount to be paid to such creditors in accordance with subsection of section 53 in the event of liquidation of the corporate debtor. Explanation 1. For removal of doubts, it is hereby clarified that a distribution in accordance with the provisions of this clause shall be fair and equitable for such creditors. Explanation 2. For the purpose of this clause, it is hereby declared that on and from the date of commencement of Insolvency and Bankruptcy Code Amendment Act 2019, the provisions of this clause shall also apply to corporate insolvency resolution process. The corporate debtor, 1, where a resolution plan has not been approved or rejected by an adjudicating authority; 2, where an appeal has been preferred under section 61 or 62. Such appeal is not time-bound under any provisions of the law for the time being in force. Number 3, where legal proceedings has been initiated in any court against the decision of the adjudicating authority in respect of a resolution plan. See, we are not concerned. So basically, our attention is whichever is higher and that provides that the payment of debt of financial creditors who do not vote in favor of the resolution plan. So that is dissenting financial creditor. Okay. So let us come out of the section, go to the topic. Topic number 53 says, the fact that resolution plan value is lower than liquidation value does not permit deviation from the mandate of section 32B. This is the case of Indian Bank and others versus State Bank of India and others, company appeal so and so of 2024 NCLAT. This is an order of Cuttack Bench, which has been challenged in NCLAT by Indian Bank, Union Bank, Bank of Baroda, and all others. This pertaining to a resolution plan distribution mechanism of pertaining to a resolution plan. The monitoring committee was constituted. What was happened that it was found that the liquidation value, the resolution plan value was less than the liquidation value. And State Bank was the dissenting financial creditor. They had appointed an agency to calculate what will be the amount payable to creditors in terms of their security interest. And State Bank being dissenting financial creditor, they got out of 150 crore resolution amount, they got 65 crores. Other banks realized that State Bank has taken 65 crores. They disallowed and they say they can take only up to 35 crores. The State Bank didn't agree. The court did not agree. NCLT did not agree to that such. And as such, the matter went to NCLAT. And NCLAT gave a long judgment, which you can see. You should go through this because this deals with it defines section 30 and regulation 38 also. And also mentions about the power of monitoring committee. So this is a very, very important case. Very, very important case. So with this, I stop the screen share here and take you to the slide which I prepared for you. I discuss on the, we must recollect the judgment of Honorable Supreme Court in Maharashtra Seamless Limited versus Padmanabhan Venkatesh and others, Civil Appeal number 4242 of 2019, and State Bank of India versus Accord Life Spec Private Limited, Civil Appeal number 9036 of 2019, in which Supreme Court opined that there is nothing in the code that says that the resolution amount should match liquidation value. Clear? So, resolution amount could be less than liquidation value also. And this is exactly what happened here. So, it is clear that the Honorable NCLAT held following. it is clear that the dissenting financial creditors must be paid higher value among the amount provided in the resolution plan and the liquidation value. So if there is a resolution value and a liquidation value, the higher of the two should be paid to the dissenting financial creditor. In the 18th COC meeting held on 23/9/2022, the COC approved a specific and structured mechanism that the distribution shall be made on the basis of the liquidation value attributable to each secured financial creditor. In the 19th COC meeting held on 30/9/2022, the COC clarified that the distribution amount amongst the secured financial creditor would be based on their respective share in the security interest and corresponding liquidation value attributable thereto. So, COC decided that the amount to be payable to them should be based on the liquidation value and attributable to their security interest. But what they did not realize is the fact that the resolution amount was less than the liquidation value. COC decided to appoint an independent evaluation advisor, KG Somani and Company LLP, to compute the liquidation value attributable to each creditor in accordance with the approved mechanism. The evaluation advisor submitted a report determining the liquidation value payable to respondent 1, that is State Bank of India, at rupees 64.56 crores, which was not challenged and formed an integral part of the framework within which the resolution plan was considered and approved. So this was a part of the approval of the plan under Section 31. In the 20th meeting, COC reiterated that dissenting financial creditor would be paid at least the minimum of liquidation value in terms of Section 32B of the Code, and thereby reinforcing rather than diluting the earlier decisions. The share proposed by SBI respondent 1 is 64.56 crores, and the same is based on the liquidation value of the steel unit. Section 32B provides that a statutory safeguard to dissenting financial creditor by ensuring that they receive not less than the amount they would have received in liquidation. Therefore, the payment of this amount is not discretionary but mandatory. So, since the liquidation value attributable, now with what happens to secured financial creditor who asserted, therein this mechanism will not happen, because the amount available in the resolution plan is 150 crores. Now, if everybody is getting according to liquidation value, then the value will be much more than 150 crores, because the resolution amount is less than the liquidation value. But because State Bank is a secured creditor and dissenting financial creditor, and that will be dissenting financial creditor, so they get the higher amount. The fact that the resolution value is lower than the liquidation value does not permit deviation from the mandate of 32B. The regulation 38(1)B stipulates that dissenting financial creditor will be paid in priority over the financial creditors who voted in favor of the resolution plan in the COC meeting. The monitoring committee constituted by COC is only for a limited purpose of supervising and facilitating the implementation of approved plan, and cannot assume the role of the COC or adjudicating authority to revisit or modify the terms of the plan. In view of the finding above, we hold that the impugned order of 5/2/24 does not warrant interference. Now, this opens a new area. This judgment is absolutely perfect, no doubt. But think of a situation where liquidation value exceeds the resolution plan value. If there are more than one financial creditor, will a financial creditor vote in favor of the plan? Because they know that in such case, if they're a dissenting financial creditor, then they'll get more. So this is a I would call it, I mean, law is supreme. I don't want to comment. But if such a thing prevails, it will be difficult for resolution plans to go through. With this, we move on to the next slide. We can see Section 25 of Insolvency Bankruptcy Code, which defines duties of resolution professional. Now, before coming to the next topic, we need to have a look at Section 25, subsection 2, subsection H. So 25, subsection 2 and subsection H says, invite prospective resolution applicants who fulfill such criteria as may be laid down by him with the approval of committee of creditors, having regard to the complexity and scale of operations of the business of the corporate debtor and such other conditions as may be specified by the board to submit a resolution plan or plans. Here the word he means the resolution professional. We know that in regulation 36A, RP is supposed to look into the eligibility of the person. But this is 36A shoots out of what? Shoots out of section 25 and section 29. So it is better we should have an idea of subsection 25 to H also. In Form G, you will find this particular row is also there, that how is the eligibility of the criteria, whether under say 25 to H is being met or not. So with this, we move to the topic. Topic number 35, eligibility of the applicant must be thoroughly examined and only those eligible should be allowed to participate. You will find this topic in 36A also. The case is of Messrs. Nirmal Ujjal Credit Cooperative Society Limited versus Ravi Sethia and others, civil appeal number so-and-so of 2025. It's a Supreme Court judgment. In this judgment, in this case, what happened was Nirmal Cooperative Society, which is a multi-state cooperative society, coming under Multi-State Cooperative Societies Act 2002, it had, besides other business, it had a textile unit called Nirmal Textile in Nagpur. There was a CIRP going on for our corporate debtor, which was also a textile unit. And Nirmal Cooperative Society applied as a resolution applicant, as a prospective resolution applicant. It also submitted EOI. They were listed in the final list of resolution applicants. And subsequent to that, they were RP term mentioned that they were not eligible to participate because they under section 25 to H, their eligibility is not being established. The matter went to NCLT and then went to NCLAT. In both cases, both forums mentioned that they are not eligible. The matter went to Supreme Court. This is an interesting read. I think my viewers will be enlightened looking at, perusing this particular case. So I would strongly recommend that you go through it. With this, let me stop the screen share here and take you to the slide which I prepared for you. As we know, that this particular topic is same in both 36A and 25-2H. Now, Supreme Court held, as per Section 64D and MSCS, that is Multi-State Cooperative Society, may invest or deposit its fund inter alia in shares, securities, or assets of a subsidiary institution or any other institution in the same line of business as the MSCS, that is Multi-State Cooperative Society. The determination of whether an institution operates the same line of business as MSCS must be made with reference to its bylaws, which constitute the decisive charter document in this regard. So one has to look at the bylaws of the Multi-State Cooperative Society. Before deploying its fund, an MSCS must satisfy a threshold condition that proposed investment aligns with its own line of business as reflected in its bylaws. The determination of eligibility under Section 64D involves an examination of the objects and functions contained in the bylaws of MSCS and a comparison with the business activities of the target institution to ascertain sameness between the two. If MSCS and the target institution have similar business operation, then only they can take it over. When bylaws are read in their entirety, the appellant's line of business is predominantly that of a financial and member-oriented cooperative with limited engagement in the agro-based business processing activities. Even though Nirmal Cooperative was running a textile mill, but its main objective is predominantly financial and member-oriented cooperative, and it had limited engagement in agro-based processing activities. The permissible business activity under Clause 5, Subclause S of the bylaws centered around agro products. Secondly, the role of the appellant is to facilitate the processing of agro products and making available modern technique to its members. The corporate debtor is engaged in the business of man-made fiber or viscose-based textiles, which involves synthetic or semi-synthetic raw materials, which is not agro-product. Under the second limb of Section 64D, the requirement is for predominantly and substantially the same or closely related business activities. Such sameness is not present in this present case. It cannot be said that the appellant and the corporate debtor are in the same line of business. So it is needless to clarify that CIRP of corporate debtor shall continue in accordance with provisions of IBC and that Nirmal Mutual Cooperative Credit Society Limited cannot be a prospective resolution applicant. So it is the duty of the RP to see the charter of the institution, if it's not a corporate body, or even if it is a corporate body, to look into the memorandum and articles of association and determine whether it is eligible under 25(2)(h) or not. And this is what makes it, this particular case is purely based on eligibility. And this is what makes it exceptional. And I would strongly recommend it. This is a nice case and one should go through this. So with this, we'll move on to the next slide. Here on the screen, on your screen, you can see the dashboard of the topics pertaining to Section 60 of IBC, in Guide to IBC website. Now, Section 60 deals with adjudicating authority for corporate persons. And we know that Section 60, subsection 5 comes with the non-abstention clause. Now, there is a story behind why I'm doing this particular topic. For the sake of confidentiality, I cannot disclose names. Well, it so happened that show cause notice was issued to an insolvency professional by IBPI based on complaint raised by a financial creditor. Now, it so happened that the financial creditor, before complaining to IBPI, had also moved parallel petitions at NCLAT. And the matters are under active consideration at NCLAT. So while looking into that, automatically a question came as to, since Section 60, subsection 5 comes with a non-obstruction clause, does IBPI have a jurisdiction to raise a question? The IP concerned, while replying to the SCN, that is show cause notice, mentioned that. But as luck would have it, on that very same day, I came across this particular topic in a Supreme Court judgment of that particular day. And the topic is two separate, that is topic number 30, two separate prosecutions are impermissible if the allegations in both the cases are overlapping. That is, if two separate prosecutions cannot happen if the allegations are overlapping. So in such case, it has to be adjudged by one court only. Now, I further naturally, this is pertaining to Insolvency Bankruptcy Code and anything for that matter. So I searched the net and I came across 4 Supreme Court judgments. One is Anorsh Ekka versus state through CBI, which is a judgment of possibly 13th of April. One was V. Anima Malar versus A.S. Adavan, which is also a very recent judgment of 2020, April 2026. And there are 2 old judgments, Union of India and others versus Tatia Construction Private Limited, and Puja Ferro Alloys versus State of Goa Civil Appeal. I recommend these are not full judgments. I have not, going by the norms followed by Guide to IBC, I've just taken out the exact paragraph or paragraphs of the Supreme Court judgment, which would be of interest to us and which deals with this particular subject. Like if you go to Union of India versus Tatia Construction, you will see just a small paragraph. Whereas if you come to Puja Ferro, it's pretty long. I mean, not very long, but it will give you views on the topic. So we get to learn more. V Anima is also, so these cases are going to be good read for you. Now, for the sake of convenience, let me take you over to the slide which I have prepared for you, which summarizes the headlines of all the 4 cases, clump them together so that it becomes easy for you to understand the case, understand the issue. So I'm stopping the screen share here and taking you over to the slide. Now, this is for the first time we have 1 topic and 4 cases, and all are Supreme Court cases. Now, what does these cases say? 2 separate prosecutions are impossible because the allegations in both cases are overlapping. The prayers concerned, prayers are the very same, prayers concern the very same property. So prayer D in suit in the writ petition are common. First respondent could not have agitated this relief before 2 forums. That means the prayer being common, it cannot be. The filing of writ petition was an abuse of the process of law. So this is considered to be an abuse of process of law. Now we are not talking of section 60, subsection 5. We are talking of principles of natural justice. The constitutional power vested in a court cannot be fettered by any alternative remedy available to the authorities. Injustice, whenever and wherever it takes place, must be struck down as an anathema to the rule of law and provisions of the Constitution. For the principle of res judicata to be applied in the subsequent proceeding, it must be between the same parties, and the cause of action in the subsequent proceeding must be the same as in the previous proceeding. Now we are coming to a situation where 1 case has already taken place, and the party has gone to another parallel court, raising the same issue. So then the question of res judicata comes. The principle of res judicata is based on the need of giving finality to judicial decisions. What it says is that once a res judicata, it shall not be adjudged again. A court having an earlier stage, the court at an earlier stage decided a matter in one way, will not allow parties to re-agitate the matter again at a subsequent stage of the same proceedings. So court in one, this is understandable. The principle of estoppel and res judicata are based on public policy and justice. Doctrine of res judicata is often treated as a branch of the law of estoppel, though these two doctrines differ in some essential particulars. That means res judicata, so what become? Natural justice. Res judicata, law of estoppel. When the proceedings attain finality, parties are bound by the judgment and are stopped from questioning it. They cannot litigate again on the same case case cause of action, nor they can litigate any issue which was necessary for the decision in the earlier litigation. So the only option left is go to higher court. So if the aggrieved party, in this case, like the SCN which we mentioned, if the aggrieved party wanted it could have, if they should have waited for the judgment in NCLAT, it could have gone to NCLAT. Or they should not have applied to NCLAT and they should have gone to IBPI. But going to IBPI and NCLT at the same time with the same complaint, in my small opinion, with small knowledge that I have, was not proper. So with this, we move on to the next slide.
We are in the halfway of our presentation. I hope you liked the judgments because all of them are quite exceptional and more are going to follow. Please do like, share our video with your friends, colleagues, and relations. Your likes do motivate us. With this, I take you over to the remaining part of the presentation.
We are on the screen of Section 62, which deals with appeal to Supreme Court. This particular topic can be applied to Section 60, 61 also, because this is a general rule, and the topic is topic number 13, which says that natural justice is a profound humanizing principle designed to imbue the law with fairness and ensure justice. Let me read it out again. The natural justice is a profound humanizing principle designed to imbue the law of fairness and ensure justice. The case we are going to deal with is State Bank of India versus Amit Iron Private Limited and others, Civil Appeal so-and-so of 2026. Needless to state that this is a very recent case. This particular judgment spans for about 106 pages, but essentially deals with a situation where a bank declares an account to be a fraud account. And what is the right of the other person? The person whose account is declared to be fraud. What right does he have to, whether he has a right to contest or not? This, of course, that doesn't come much use for insolvency purpose. What is useful to us is to know the aspect of natural justice and its reach of the principle. It's a wonderful piece which we have picked up from the judgment. And I would recommend all my viewers to go through it because this would impart a very good understanding on the subject. With this, let me stop the screen share here and take you to the slide which I prepared for you. So we have already read that natural justice is a profound humanizing principle designed to imbue law with fairness and ensure justice. Now, we need to also, many of us are not familiar with legal terms. So there is a Latin phrase which comes often in this particular discourse, which is audi alteram partem, which means the right of the opposite party to be heard. Now, what does the judgment say? The principle of natural justice, particularly the rule of audi alteram partem, had to be necessarily read into in the master directions on fraud to save it from arbitrariness. Audi alteram partem depend on the facets of and the circumstances of the case. It talks of RBI's master circular on declaring an account to be a fraud account. So the court says, Supreme Court said that the right, the factor or the factum of natural justice should be imbued in that. Because until and unless it is imbued in the master circular, it will not be correct. It will not be correct. And with the court further held, the basic scheme of statute under which the administrative powers is exercised, as well as the nature and purpose for which power is conferred, and the final effect of the exercise of that power needs to be analyzed. So what the administrative section is given power. So the power is there, but once the power is exercised, what is going to be the effect? Following Newton's law, every action has equal and opposite reaction. So the final effect of exercising such power has to be analyzed in order to determine how the rule of natural justice uh, is to be exercised. While consequences for an account to be declared as fraud is the same as willful default, in the case of fraud account, the certain additional consequences also ensure. The bar from raising finances from financial markets, capital markets, which were to visit the borrowers if the account is classified as fraud, tantamount to civil death, apart from being a violation of Article 19(1)(g). You are not allowed to visit the financial market, capital market, visit borrowers. If those things are curbed, then it means a civil death for any business or any person, to be precise. Principles of natural justice should be made applicable, and that a person against whom an action of debarment is sought should be given an opportunity of being heard. The ultimate objective of principle of natural justice is to ensure fairness in action and prevent miscarriage of justice. This is the ultimate requirement of natural justice. Even in the application of doctrine of fair play, there must be real flexibility. A yet higher facet is where, in the said process of personal hearing, he be given the facility to be represented by a lawyer or a legally trained mind is guaranteed. If the situation is such that a person, legal aspects are involved. Say, for instance, we are facing a case of fraud or something, or in NCLT or High Court or any. You should be having the right to employ a lawyer, deploy a lawyer, or a person equally trained to represent your case because he knows the subject better. But however, one cannot start with the assumption that as of right, a notice is entitled to personal hearing. It is not a matter of right for one person that he must be given personal hearing. In the absence of any rule prescribed in the statute or rule or in regulations or in any policy, what would meet requirement effectively would depend on the circumstances and nature of the inquiry. So it depends on the nature of inquiry, depends on the nature of fraud, depends on the grievance, nature of gravity of the situation. The law of natural justice has to be applied. So this is a beautiful judgment, beautiful piece of judgment. And this is for not only for Insolvency Bankruptcy Code, but for any purpose. This is important. And that is why this slide is important. With this, we move on to the next slide. Now we are on the screen, or we are on the dashboard of Section 95 of Insolvency Bankruptcy Code, which deals with application by creditor to initiate insolvency resolution process against personal guarantors here. It's actually applicable on individual and partnership firms, but since individual and partnership firms are not working at the moment, the regulations have not come out. So that is, it is essentially concerning personal guarantors. Now, the topic we are coming to is topic number 52, which says that any attempt which is made by the creditor to set back the date of default is not acceptable under the eyes of law, as the default in itself happens to be in specific determination to the provisions of the law. It sounds rather difficult, isn't it? Any attempt which is made by the creditor to set back the date of default is not acceptable under the eyes of law, as the default in itself happens to be in specific determination to the provisions of the law. This case is of T. Venkatram Reddy versus L&T Finance Company Appeal, so-and-so, NCLAT, Chennai bench. This is quite a dynamic judgment, I must say, and one should go through this because it talks of it, and you will find this topic also in section 238A, which essentially deals with limitation. This pertains to a case where L&T Finance and the corporate debtor had entered into an agreement in 2011, 11 or 12, and the default was supposed to take, and default had taken place in 2012. They had gone into arbitration, and then thereafter Bombay High Court passed an order, and Section 7 petition was moved, and also personal insolvency of the promoter was initiated under Section 95 of the Code. The court looked into the matter. Honorable Court, NCLAT, Chennai bench looked into the matter and gave decision which is quite dynamic in my opinion. So I would strongly recommend everyone to go to the excerpts of the judgment. Let me take you from here and let me take you to the slide which I prepared for you. A default under the IB Code 2016 would be a single event which chances and necessitates the issuance of notices for drawing the proceedings under Section 95 of IB Code. It is not a recurring or variable. It is not recurring or variable. It's definite in nature. Now, this we are hearing for the first time. A default under IB Code 2016 would be a single event which chances and necessitates the issuance of notices for drawing the proceedings under Section 95 of IB Code. And it is not recurring or variable, it is definite in nature. It is apparent that the demand notice was issued on 20/1/2020. It mentions the date of default as 1/8/2012. Since the application mentions the date of default as on various dates, 1/8/2012, 19/6/2017, 13/2/2020, has to be the date of default, dates of default that has been derived because of refusal to pay the debt, which has arisen as of the date of demand notice. The law under the IB Code do not contemplate that while determining the aspects of limitation, the impact of pending proceedings should not be taken into consideration while determining the limitation as per 238 of IB Code. Yes, we know that. If the matter is being proceeded with in other courts, the IB Code will take those into account. An accrual of debt would be followed by the issuance of notice under subclause B of subsection 4 of 95 of the Code, when there is a failure after service of notice by the debtor to pay debt. Obviously, as soon as demand notice is issued, the fact of debt which has not been specifically denied by appellant too would be treated to have been existing debt necessitating initiation of proceedings under Section 95 of IB Code 2016, which is also understandable. In the definition of default, one specific expression is when. Section 3, subsection 12, I think, mentions what is default. So therein, a phrase is when is used. So in determination of default, one specific expression is when, which gives an explanation and a meaning to a singular moment for determining of a default, and it can never be read to intend to give it a continuous motion of transactions of default, attracting Section 129 of Contract Act. The court denied that default is one singular event. It cannot be continuous. None of the conditions of Schedule 2 of Facility Agreement is for continuous repayment of loan facility on commission of default. They refer to the facility agreement executed, and it said it is not a continuous default. They mentioned that the date of default is when the default was mentioned. And it stated that the money has to be paid on so and so date. So it is payable on so and so date. So matter irrespective. The date of default, which has already been expressed in the notice under section 95 subsection 4b of the IB Code 2016, has to be taken as to be 1/8/2012 and cannot be extended merely because the demand notice was issued on 2/21/2020. The date of default remains what? Remains 1/8/2012. It cannot be extended to 21/2018. Any attempt which is made by creditor to set back the date of default is not acceptable under the eyes of law, and the default in itself happens to be specific determination to the provisions of the law. The arbitral award happens to be that of 15/3/2013. Thus, even considering the date of arbitral award itself, the limitation will get attracted. Because arbitral award is a renewal of debt. So 3 years. So it comes to 14/3/2016. Still then the limitation will get affected. Section 238A would also be made applicable over the defaults occurring for the period to the insertion of 238A. The question came that at the time when this matter default took place, IBC was not there. So will 238 work? So the court referred to a Supreme Court judgment and said 238A would also be made applicable over defaults occurring prior to insertion of 238 to the court. So it has a retrospective effect. The impugned order of admission of the appellant to the insolvency process under 95 of IB Code would hereby stand quashed, and all interlocutory applications would stand closed. So the court quashed the entire petition, and the 95 petition, which was moved by L&T Finance, was set aside. So with this, we move on to the next slide. We are on the screen of section 96 of Insolvency Bankruptcy Code, which deals with interim moratorium in the case of personal insolvency, or other insolvency of, at the moment, you can say the personal guarantors also. We know that section 96 comes into force as and when a petition under section 94 or 95 is deposited, is submitted at NCLAT, and it gets numbered and the interim moratorium starts. Once an order comes under section 100, moratorium under section 101 follows. Having said that, let us go to the topic. We are coming to topic number 20, which says that the language of the section 96 subsection 1 of IB Code cannot be stretched to include all co-guarantors within the ambit of the interim moratorium. The cases of IL and FS Financial Services Limited versus Servial Construction Private Limited and others, commercial summary suit number 238 of 2019, Bombay High Court. Though this is 2019, this is a very recent judgment. Now, this particular case is unique in the sense there was one principal borrower. It had corporate guarantors as well as personal guarantors. Pertaining to corporate guarantors, already section 7 had been moved and CIRP had been admitted. And even with regard to personal guarantors also, section 95 had been invoked. But however, against the principal borrower, nothing had. No case, no proceeding was going on. So the matter went to Bombay High Court. And they were to adjudge as to what is the effect of this. There was a section 14 moratorium as far as CIRP was concerned, An interim moratorium under Section 96 with regard to personal insolvency was concerned, 95 was concerned. So, what was the effect on the principal borrower against whom no proceedings had been moved? This is an interesting read. So, we all can understand, having gone through the Act, and that there will be no effect on the personal guarantors. But this is a case law which we need to refer to. Okay. So, with this, I stop the screen share here and take you to the slide which I prepared for you. What does the court say? By an order dated 20th August 2019, passed by NCLT and confirmed by NCLAT by order dated 13th July 2020, a moratorium under Section 14 of IB Code has come into effect against defendant number 2. On 18th December 2021, applications under Section 95 of IB Code were filed against defendant number 3 and 4. Consequently, an interim moratorium under Section 96 of IB Code came into effect. The company petition against defendant number 3 was also reserved for order on 24th July 2025. No proceedings are initiated against defendant number 1 under IB Code. Therefore, the moratorium under Section 14 would not apply to defendant 1, and moratorium order cannot prohibit the continuation of suit against defendant number 1. Even if resolution plan or repayment plans with respect to guarantors are approved, it will not amount to discharge of the principal borrower, that is defendant number 1, from liability to repay debts. Even if resolution plan or repayment plan is approved with regard to the corporate borrower against whom the CIRP has come into effect, and if the personal guarantors also, if the order comes under to Section 100 and repayment plan gets approved under Section 114, in such case also, the liability of the principal borrower would continue. Of course, to the extent of recovery to be made on account of this will get set, but the liability will remain to the extent of the amount which remains unrecovered. In view of 96(1)(b), during interim moratorium period, any legal proceeding pending in respect of any debt shall be deemed to have been stayed. The language of Section 96(1) of IB Code cannot be stretched to include all co-guarantors within the ambit of interim moratorium. That means the interim moratorium applies to the one against whom 95 has been moved or 94 has been moved. It cannot apply to a second person. Section 96 of the Insolvency Bankruptcy Code also uses expression all debts in clause A of subsection 1 and any debt in subclause 1 and 2 of clause B of subsection 1. It is clear from the language of section 96(1)(b)(2) to the effect that the creditors of the debtor shall not initiate any legal action or proceeding in respect of any debt. The effect of interim moratorium is limited to the debt of a particular debtor, and the interim moratorium under Section 96 in respect of one co-guarantor would not ipso facto apply to other co-guarantors. It applies to one guarantor only, against whom 94 or 95 has been moved. The word any debts used in Section 96 of IB Code cannot be stretched to benefit the debt of principal borrower against whom no proceedings under IB Code has been initiated. So this is a very important judgment. In a case, this is a rarest of the rare cases that there is no suit moved against the principal borrower, but only against the guarantor, which is permissible under if you go by Lalit Jain judgment. So this deals with a situation like that. And this case, from that point of view, is an exception and should be read. With this, we move on to the next slide. We are on the dashboard of Section 114 of Insolvency Bankruptcy Code in Guide to IBC. Our attention is topic number 2, the adjudicating authority needs to be satisfied that the repayment plan requires modification based on materials placed before it. The order under Section 114, the repayment plan requires modification. The cases of Mr. Omkaram Venkata Ramana versus Bank of India and others. Company have been so and so. NCLAT Chennai bench judgment. In this, what happened was there was a personal insolvency. The repayment plan was given. Bank of India was the main creditor, and they did not accept that. They took a number of adjournments. They took a lot of time to approve it, but at the end, they did not approve the repayment plan. The repayment plan not being approved, the NCLT, when it went to it passed an order stating that repayment plan is not approved, and so the bankruptcy proceedings can start. The promoter challenged, the personal guarantor challenged it in NCLAT. That under Section 114, the court can, the NCLT can order for rechecking of the plan. The total debt owed by the personal guarantor was something in the region of about 700 crores, if I'm not wrong. And he had offered 68 lakhs. So NCLAT took the view that such order cannot be given. And the matter went to NCLAT. So while recommending that you go through the excerpts of the judgment, I would take you over to the slide which I prepared for you. I've read the topic, so I'm not repeating it. But before coming to the headlines, I would like you to recap what is Section 114. Section 114 deals with order of the adjudicating authority on repayment plan. The subsection 1 says the adjudicating authority shall by an order approve or reject the repayment plan on the basis of the report of the meeting of the creditors submitted by the resolution professional under Section 112. Provided that where a meeting of creditors is not summoned, the adjudicating authority shall pass an order on the basis of the report prepared by the resolution professional under Section 106. Subsection 2 says what the order of adjudicating authority approving the repayment plan may also provide for directions for implementation of the repayment plan. Subsection 3 says where adjudicating, subsection 3 of section 114 says what? Where the adjudicating authority is of the opinion that the repayment plan requires modification, it may direct the resolution professional to reconvene a meeting of the creditors for reconsidering the repayment plan. So that means adjudicating authority has the option to direct the RP to reconvene the meeting of the creditors and ask the PG to modify the repayment plan and submit it again to the committee of creditors for consideration. Now let us come to the headlines. The proceedings under Section 94 of Insolvency Bankruptcy Code, which were initiated against the appellant, admittedly, it was regarding to the dues which were outstanding against the appellant were shown to be more than 106 crores. The repayment plan which was submitted by appellant was for an amount of 68.84 lakhs. The repayment plan, which was placed before the Committee of Creditors, was considered by the Committee of Creditors too after obtaining several adjournments. Which I told you, Bank of India took several adjournments because banks invariably refer it to their higher management and it takes time. Though IBBI has informed multiple times that people should come to attend the COC meetings being duly authorized to take decisions, but it actually doesn't happen. The minutes of the meeting of the creditors from 21/2/2022 to till 31/3/2022 have been brought on record by the appeal. The bank had communicated that they are not relinquishing security and that they had a claim of 736.64 lakhs crores. 764 lakhs. That is 7 crores 36 lakhs. The resolution professional in the meeting had noted that Bank of India had not voted for the repayment plan, which had the voting right of 71.22%. So, if 70, in any case, it requires about approval of more than 75%. So, and the Bank of India, which had 71.22%, had not voted. Repayment plan could not get the minimum required voting rights. It was not obligatory for the learned adjudicating authority to direct reconsideration of the plan. So, there has to be material which should be placed before adjudicating authority to consider that a plan should be reconsidered based on material facts. Now, when you have dues of 106 crores and you give a plan for 68.84 lakhs, so the court may consider that it is not proper for it to send it back to a committee of creditors for modification of the plan and to for the creditors to reconsider it. Because the difference between 68.84 lakhs and 106 crores is quite a bit. No grounds have been made out to interfere in the impugned order in exercise of our appellate jurisdiction. So no grounds. I mean, you cannot compel an order to the adjudicating authority to send it for reconsideration. That does not happen. So this is an exception, and which I wanted you to note, and that is why this particular presentation. With this, we move on to the next slide.
We are at the end of this podcast. Hope you liked the judgments, which were all exceptional, and they gave something new, some new approach to each and every topic. Each and every topic selected were new and gives a dynamic approach. Please do like, share our videos with others, your friends and colleagues, and please do let a comment on our presentation because your comments are immensely valuable because they help us in improving us. We'll see you again with our presentation towards the end of this month. Like we always do, we do the presentation on fortnightly basis. So till then, bye for now.